Consumer Proposal Calculator Review. Introduction. A consumer proposal calculator is important to figure out what sort of debt settlement plan should be offered to your creditors. But to have a truly successful one, you really need clear language. In Brandon's blog, I review a recent court case that explains why. Shelley Gale Corriveau bankruptcy. I recently read the reasons for decision dated June 13, 2019 by Registrar in Bankruptcy L.A. Smart of Court of Queen's Bench of Alberta. This case is in the matter of the bankruptcy of Shelley Gale Corriveau. The case references Corriveau, Re. 2019 ABQB 438, Ken Lee. Ms. Corriveau filed an assignment in bankruptcy in April 2012. She had unsecured creditors of roughly $73,000. The reason for her insolvency was stated as offering monetary help to her child's business. She was by all accounts a perfect example of an honest but unfortunate debtor. At the time of the bankruptcy, her only asset was her house. In June 2012, Ms. Corriveau got a gift from her mom of $46,000. It featured instructions that $6,000 of those funds be utilized for children and certain other matters. She spent the $6,000 as instructed, with the balance of the $40,000 being paid to her licensed insolvency trustee, formerly called a trustee in bankruptcy, the trustee, for the benefit of her creditors. The home was sold in October 2012. From the sale, she received her provincial exemption of $40,000 with a balance of $3,916.21 being paid to her bankruptcy estate. Ms. Corriveau files a consumer proposal. On May 12, 2013, Ms. Corriveau advised her trustee she had received an inheritance of $15,000 from her mother's estate. On May 26, 2013, Ms. Corriveau submitted a consumer proposal. The trustee served as the administrator of the consumer proposal. The proposal in paragraph 4 states: 4. That the following payments be made to, name omitted to not embarrass the guilty, trustee in bankruptcy, the administrator of the consumer proposal, for the benefit of the unsecured creditors. Proposal payments to total $10,000. The of, sic, funds will be provided to the administrator as follows: $300 filing fee to be paid at time of filing and then lump sum payment of $9,700 due 60 days after the proposal is court approved, all payments to be made within the 60 months proposal period. The debtor reserves the right to accelerate payments should funds become available. Note: there will be a significant dividend paid from the Bankruptcy Administration. In accordance with the requirements of the Bankruptcy and Insolvency Act, RSC, 1985, c. B3, BIA, the Consumer Proposal Canada read that the payments must be completed within 60 months. The trustee recommended acceptance of the proposal. In his report to creditors he stated, "This proposal will provide the debtor with relief and allow the debtor's affairs to be restructured in an orderly fashion. It will allow the debtor to annul her bankruptcy and provide for a greater return to the creditors when compared to the bankruptcy option." The consumer proposal was deemed accepted by the creditors and approved by the court. Ms. Corriveau made all the required payments and received her certificate of full performance on August 2, 2013. Have you noted the problem yet? Under the BIA, a bankrupt is allowed to lodge a proposal with the trustee, either a consumer proposal or a Division I proposal. In either format, it is a debt settlement plan that the bankrupt is proposing for acceptance by the debtor's creditors. By definition, if the proposal is fully carried out, then the person or company's bankruptcy is annulled. When bankruptcy is annulled, it is declared to have had no legal existence. It is as if it never happened. The annulment of the bankruptcy takes place upon the approval or deemed approval by the court of the consumer proposal. There will never be a distribution to the creditors from the Bankruptcy Administration. The trustee in this case did not issue any funds from the bankruptcy, yet. So the note that the trustee added, "There will be a significant dividend paid from the Bankruptcy Administration," is problematic. Actually, it is more than problematic. It is just plain wrong. Now the trustee wishes to complete the Bankruptcy Administration. The trustee submits its statement of receipts and disbursements as required to the Superintendent of Bankruptcy, OSB, for approval. This issue came before the court because of the OSB's unfavorable comment letter dated June 15, 2018. The court's analysis. Section 66.42 of the BIA states: where consumer debtor is bankrupt. 2. Where a consumer proposal is made by a consumer debtor who is a bankrupt. A. The consumer proposal must be approved by the inspectors, if any, before any further action is taken thereon. B. The consumer debtor must have obtained the assistance of a trustee who shall act as administrator of the proposal in the preparation and execution thereof. C. The time with respect to which the claims of creditors shall be determined is the time at which the consumer debtor became bankrupt, and D. The approval or deemed approval by the court of the consumer proposal operates to annul the bankruptcy and to revest in the consumer debtor, or in such other person as the court may approve, all the right, title and interest of the trustee and the property of the consumer debtor, unless the terms of the consumer proposal otherwise provide. There is a similar provision for Division 1 proposals. The court looked at the statute wording of the consumer proposal, trustee's report to the creditors on the consumer proposal, and the trustee's actions in administering the proposal. The court had to decide if the note was a term of the proposal or not. The registrar took all factors into consideration, including that the trustee issued to Ms. Corriveau the certificate evidencing full completion of the proposal upon her payment of $10,000. The registrar decided that the note was an unfortunate error in that the only intention was for the creditors to share in the distribution from the consumer proposal with a gross value of $10,000. Now for the treatment of the funds collected by the trustee under the bankruptcy that is now annulled. The registrar further concluded that consumer proposals that purport to also include a distribution from the funds held in the bankruptcy administration must include clear and precise language in the proposal. The registrar said that the trustee failed to do so. Therefore, the registrar concluded that subject to any entitlement to fees by the trustee from the bankruptcy administration, the funds held in the annulled bankruptcy are Ms. Corriveau's property and should be returned to her. Costs of the application will be dealt with at the taxation of the trustee's account. The trustee was directed to arrange a suitable date for the taxation to proceed before that registrar. Consumer Proposal Calculator Summary. A proposal must offer the creditors a better result than what they would get in a person or company's bankruptcy. So although a consumer proposal calculator is important, I think clear language is more important. Are you in financial distress? Do you not have sufficient funds to pay your commitments as they come due? Call the Ira Smith team today so we can remove the anxiety, stress, pain and discomfort from your life that your money troubles have created. With the distinctive roadmap we establish simply for you, we will quickly return you right into a healthy and balanced problem-free life. As a trustee, we are the only experts recognized, licensed and supervised by the federal government to give insolvency recommendations and to carry out insolvency procedures. A consumer proposal is a federal government-authorized debt negotiation strategy to do that. We will assist you to choose what is best for you to rid yourself of your debt problems. Call the Ira Smith team today. We have years as well as generations of experience helping people and companies searching for debt restructuring, a debt negotiation strategy, or a consumer proposal Ontario to avoid bankruptcy. You can have a no-cost evaluation so we can aid you to repair your financial problems. Call the Ira Smith team today. This will let you return to a brand new healthy and balanced life, starting now.